Well, good morning, good afternoon to just everyone that's able to join us today from ONEgeneration Senior Enrichment Center, our health and wellness webinar week. We are so excited for everyone that's attended with us yesterday and to this morning and just been with us with ONEgeneration. We're so grateful for this opportunity to have so many great speakers here today. For those of you that do not know me, my name is Niambi Cooper. I'm the new director for ONEgeneration Senior Enrichment Center, and we're led by our organization's president and CEO, Jenna Haas. So for this presentation today, we'll have a layout of the beginning part of the presentation. We'll have our speaker talking, and at the end, we have some questions and answers, but feel free throughout the presentation to use our chat function at the bottom part of your screen, and also you can use a raise your hand function if you see that at the bottom part of your screen as well, and that will allow you to verbally ask a question for our presenter. So this presentation is being recorded, so we will be able to have access on our ONEgeneration newsletter. So if you do not have access to our newsletter, that's completely fine, but we can get you signed up today. So if you could just give our office a call, I will place that number into our chat. It's 818-705-2345, and we can get you signed up, and you'll be able to watch the recording over again, and you can share it with friends and family, so that way they can have the information as well. So I'm super excited to introduce from the law offices of Sara Polinsky. We have Sara Polinsky here today. So she will be presenting on a topic titled Most Common Planning Mistakes People Make. So this will be just a great discussion and overview of myths and truths about trust, wills, property ownership, and just planning for incapacity and more. So thank you so much, Sara, for being here with us. We're super excited just to learn about everything. We're just ready to soak everything up. So how are you doing?
I'm good. Thank you. Thanks for having me and for this opportunity to provide some important information and some education and some important tips to know so people can make good decisions moving forward.
For sure. Let me go ahead and share my screen. Let me, okay. Are you able to see my screen?
Yes.
Okay. Perfect.
All right. Should we get started?
Yes, I'm going to spotlight you for everyone so they can see you. Awesome. We are ready.
Okay, great. Well, hi, everybody, and thanks for joining. And I appreciate your time this morning. And I think it's so great, all the speaker series. It's so important, a lot of good information. I've been practicing for over 20 years as an estate planning and elder law attorney. And so these common mistakes are things that I have heard over and over through the years that I wanted to share and address and dispel any kind of myths or misunderstandings. So let's jump in and start with mistake number one, which is joint tenancy ownership of property. Joint tenancy is a form of co-ownership of property. And so very often when more than one person owns property together, they own it as joint tenants. Joint tenants is very familiar to people, and it's also popular because it does help to avoid probate when somebody passes away. But what people don't realize is that there are a lot of unintended consequences with joint tenancy that can cause some negative impacts to owning as joint tenants. And I wanted to highlight a couple of those. The first is disinheritance of heirs. If a single person or a widowed person, let's say that has 3 children, decides to add one of their 3 children as a joint tenant to their property, thinking that when they pass away, it's an easy and quick way to avoid probate. That is true, it does, but the minute they add one of their 3 heirs to the title, they automatically disinherit the other 2. And so joint tenancy supersedes every other type of transfer or plan of transfer of property, including inheritance. If somebody has a will that says, I want my 3 children to share equally in this property after I pass away, if they had a living trust and the property was taken out of the trust and put into this joint tenancy situation. And in the trust, the three children were named as equal beneficiaries. As soon as the parent added this one adult child to the title as a joint tenant, the other two are disinherited. So joint tenancy does create a disinheritance situation, and oftentimes it's unintentional. The other issue is loss of control. When you own your property, you can do whatever you want, whenever you want. You can refinance it, you can sell it, you can do a reverse mortgage if you need to pay for care in the future. But when you add somebody else onto title, now whatever decisions you make are dependent on their agreement to do those things. And you are also potentially exposing your property to now your new co-owner's financial issues. If they file for bankruptcy, if they get sued, if it's a married adult child who now is going through a divorce, but over the time of the marriage, they helped you to make repairs or put a new roof on your house or anything like that, your house can now become a claim to that co-owner's legal and financial claimants. And so giving up control and ownership and exposing your property is often an unintended consequence of adding somebody onto title. In order to avoid probate, there are other ways to do that without having to give up control or exposing yourself to unnecessary claims. So I just want everyone to be mindful and have a good understanding of what joint tenancy is. Okay, mistake number 2, waiting until somebody is incapacitated to get a power of attorney. This is very, very common. A very typical call that we receive in our office is, my wife, my husband, my aunt, my sister has had a stroke, has been diagnosed with dementia and Alzheimer's, is no longer competent, and I need to help them make their financial decisions. I need to help them pay their bills and sign their checks. So I need to get a power of attorney so I can do those things for them. Unfortunately, the problem is that it's too late. A common myth is that the person signing the power of attorney is the person who will be taking care of the affairs and the decision making and helping out, but that's not true. The person who must sign the power of attorney is the person giving away the power. So the way a power of attorney works is that today, while you are of sound mind, you are signing the power of attorney and naming someone you trust to act for you in the future when you are no longer competent. Your incapacity is what allows the other person to take over when the time comes. But if you haven't signed or created a power of attorney during your healthy lifetime when you have capacity, then it will be too late for someone to get a power of attorney for you after you become incapacitated. And then they would have to go through a process called a conservatorship, where they have to go through the courts to get permission from a judge to make your important decisions for you. Okay. Mistake number 3, thinking that a will avoids probate. This is also a very common one. Many people think that as long as you have something written down about your wishes, including a will, that you can get a form, you can handwrite, or you can do it through an attorney, as long as you have a will, that allows you to avoid probate at your death. And that is not true. A will is typically required to be probated if you have certain types of assets. In California, if you have real estate worth $50,000 or more, it may be subject to probate if you only have a will. And if you have liquid assets, bank accounts, investments, stocks, and bonds, with the exception of retirement accounts and life insurance. But if you have liquid assets that have a combined total of $166,000 or more, and you don't have beneficiaries or anything like that, those may be subject to probate. And so If you have property or high value liquid assets and you only have a will, it may end up going through, your estate may end up going through probate if you don't have other safeguards in place, like a living trust or beneficiary designations and things like that. So a will in and of itself does not avoid probate. Okay, moving on to mistake number 4. Not funding a living trust. So for those of you that have a living trust, you know that your wishes about who gets your stuff are in the trust. Those of you that don't have a living trust, that is one of the main functions of a living trust, is to put down your wishes and instructions for who's going to inherit property after you pass away, among other things. But if the trust doesn't own any assets in order to pass them along at your death, then none of that will happen. So the best way I like to explain to my clients is if you think of a living trust as a box. So the papers that you have are the box. And then whatever you put into the box are the things that you want to pass on to your loved ones: property, bank accounts, investments. Putting the stuff in the box is what's called funding the trust. You have to put the name of the trust on the title to those assets in order for those assets then to be distributed to the trust beneficiaries. So if I have a house and the name on my house is Sara Polinsky, when I set up my trust, I'm going to change the title to say Sara, trustee of the Sara Polinsky Trust. Once I put the name of the trust onto the title of my property, that property is now considered to be in the trust and will be distributed to my trust beneficiaries when I pass away. During my lifetime, I'm still the owner, I'm still the manager, I can do whatever I want, sell it, buy new property, whatever it is. But by putting the name of the trust onto the title, I have now funded the trust with this property or transferred this property to the trust. Unfortunately, we see many times people who have trusts, but who never transferred their property to the trust, or had property in the trust, then sold it, then bought new property and didn't put it in, or maybe they refinanced their property and the lender took it out of the trust and it was never put back in. But the fact of the matter is that if at death you have a living trust, but it doesn't own property, those assets will still end up going through probate, even though you have a trust. So you have to be careful that having the trust is great and it's good planning, but you have to make sure that the trust is properly funded. Mistake number 5, failing to update beneficiary designations on retirement accounts and life insurance. As I mentioned a few minutes ago, certain types of assets like retirement accounts and life insurance policies typically are not subject to probate because they have beneficiary designations specified on the contract. And so when you pass away, when you have those types of assets, they will be distributed to the beneficiaries who are named on the contract. The problem is that people then take these kinds of designations for granted and often don't review the designations or update them. And we've had situations where somebody has a spouse who has predeceased them and they didn't update it. And so now when they were to pass away, all of that goes into their estate, which can go into probate depending on the amount. They have an adult child who they have been estranged from for over 20 years. They've disinherited that child throughout their legal documents, like the trust and things like that, but they didn't update the retirement account. So at their death, that estranged adult child will still receive the proceeds from the account. So updating beneficiaries really on all things, wherever you have them, but especially on retirement accounts, life insurance policies, annuities, it's really important to have a look at those every couple of years to make sure that the designations reflect what your current wishes are. All right. Mistake number 6, failing to update your documents or your estate plan. Following along the same lines, it's really important to make sure that your legal documents reflect what your current wishes are. Life goes on and things happen and things can change, and all of that is fine so long as your documents reflect what your current wishes and what your current situation is. So, if you have somebody named to be your successor trustee, or you've given power of attorney to someone who has passed away, who has become incapacitated, who is no longer in your life, it's important to update your documents to replace those individuals with someone that you want. A lot of my younger clients who did trusts when their children were minors are now updating their trusts and naming their adult children as their successor trustees. I have clients who are changing beneficiaries to include grandchildren to receive something, whereas before there were none to add. So uh, you don't have to do things to your documents on a regular basis or every year or anything like that. But certainly when things change in your life, it's a good time to revisit and review and make sure that your documents reflect what your current wishes are. Mistake number 7, choosing the wrong person to handle your affairs. Who you choose to be in charge to make decisions for you is super important, because these individuals are going to be the ones to act for you, not only when you pass away, but also while you're alive in case you become incapacitated. You should pick people based on their relationship with you, someone who you have a good, close relationship with, who will show up for you and be there for you. Um, Remember that these individuals can always hire professionals to assist them. They don't have to necessarily be professionals themselves. They can hire a real estate agent to help sell a house, and they can hire an attorney to guide them through the legal processes. They can hire an accountant to do the taxes. It's much harder to hire someone who will have compassion and good judgment to do what's best for you at a time when things might be challenging. So, not wanting to hurt somebody's feelings and putting them in charge as a successor trustee just because you don't want them to see that you didn't name them, um, but knowing that that person is not the best one is not a good idea. I often tell my clients that this is a good time to be selfish and think of what's best for you, so that when and if the time comes that you need somebody to act for you to make these important decisions, you will have confidence in knowing that you'll have peace of mind and everything will be okay. Mistake number 8, controlling from the grave. It's hard to think about how we want to leave our mark on our loved ones and what we want to do for them. And all of my clients come from the most loving and best place possible when they get their documents set up. But sometimes planning for too many what ifs is confusing and can cause some stress. And that's what I call controlling from the grave, is extending distributions, for a very long time, or putting siblings in charge of their other siblings' inheritance, which can cause problems among them. You just want to be careful in controlling the distribution after you're gone. I mean, in some cases it's necessary and we can plan for that, but controlling from the grave is not typically a great idea because it creates conflict potentially among your survivors, and can be problematic for those continued relationships. Mistake number 9, failing to establish competency at time of signing. Unfortunately, when people pass away or become incapacitated, sometimes there's family turmoil or conflict. And one of the easiest way to undo legal documents is to say and prove that somebody was not competent at the time of signing, or that they signed the documents uh, under undue influence or duress from the pressure of others. It's a matter of good practice, in my opinion, to establish that someone is competent at the time that they're signing their documents. And so I often ask clients to provide a doctor's letter saying that they are competent and able to make their own decisions at this time. And that adds an extra layer of security that at the time the documents are signed, this person was not acting under undue influence and understood what they were doing. And so it helps to protect the integrity of the documents and what the client is trying to do. Mistake number 10, not seeking long-term care benefits because you own a home. This is an ongoing myth and misconception. I can't tell you how many times over the years I've met families who needed to place someone in a nursing home for care. They needed the extended care, but it's so expensive, and they felt that because they owned a home that they wouldn't be able to apply for or qualify for long-term care benefits, specifically Medi-Cal benefits, to help pay for nursing home care. And that is not true. Under California law, you can own a home and you can qualify for Medi-Cal long-term care benefits to help pay for care, even if you're a homeowner, so long as you as the patient have what's called a subjective intent to return home. Subjective intent means that if it were up to you and really any patient in a nursing home facility, they would all much rather be in their own home than where they currently are. And so as long as there's a subjective intent to return, even if they can't physically be in that home, the home is an exempt or non-countable asset and does not disqualify anyone from applying for Medi-Cal benefits to help pay for nursing home care. So that's really important to know. And then further, the house is not recoverable under current regulations, which can always change, but under current regulations, if the home is in a living trust and somebody received Medi-Cal benefits during their lifetime, when they pass away, there will not be recovery against the home if it's in a living trust. Only at this time for property that's passing through probate. Okay. So if you have a loved one and they need care and you own a home, the home does not prevent eligibility for long-term care Medi-Cal benefits. All right, moving on. Mistake number 11, overlooking HIPAA and its impact on outdated documents, particularly healthcare directives specifically. HIPAA is a set of privacy rules in the healthcare industry that makes your medical information private and confidential. If I called my client's physician and asked them to share my client's latest medical diagnosis, the doctor can't do that because of the privacy regulations, effectively HIPAA. But when you become incapacitated and somebody has to act for you using power of attorney documents or the healthcare directive, you do want them to have access to your medical information, and you want your physicians to release your medical information to them so that these individuals can make knowing and informed decisions on your behalf. So nowadays we have HIPAA waivers that are signed that go in conjunction with the healthcare directives and are part of the estate planning documents. If you have outdated documents or if you don't have a HIPAA release as part of your documents, it's important to have that to enable whoever's going to be acting for you to be able to have access to important medical information on your behalf. Mistake number 12, relying on others for information, which sometimes, turns out to be incorrect. Whenever I do seminars, live seminars, and I've done a lot of them over the years, without fail, somebody will always ask, well, I heard from my neighbor's sister that this happened, or my brother's girlfriend told me that this happened. Sometimes even professionals who are doing their best to assist clients, but aren't fully familiar with the information they're discussing, can unintentionally give out incorrect information. So the rule here is go to the right person for the correct information. There's a lot of information on the internet. There's a lot of information as people are going through things and living through difficult situations and sharing that with their friends and loved ones. But at the end of the day, you want to get the right information from the right person. Um, so, I say you wouldn't take your car to the doctor to get it fixed, and you wouldn't take a broken arm to the mechanic. So, getting the right legal information from the right individuals is important when you're making decisions that will affect your well-being and your future, and the future for your family and loved ones. Mistake number 13, omitting an heir. An omitted heir, which is a forgotten heir, has protections under California law. If you have a legal heir and you make no mention of them as if they don't exist, they can be presumed to be forgotten or unintentionally left out. Um, Sometimes I have clever clients who think that by not naming someone, um, one of their kids, let's say, they're protecting the other kids, making sure that everything will go to those children. And that's a problem. You always need to name all of your legal heirs and acknowledge them and acknowledge that they exist. You can then disinherit them and exclude them to show that you've acknowledged them and then made a decision with regards to they receive something or they receive nothing. But to just not name them will be a problem, and it's a mistake. Also, something to think about: if you have a deceased child and they left children behind, even if you're estranged from them, those grandchildren or those children of the deceased child are legal heirs. And so if you do not want them included in your estate when you're getting your legal paperwork together, that's something that should also be addressed. Mistake number 14, changing documents to appease others. This is something that as an elder law attorney makes me uncomfortable, and I really, it's a problem for me. I get calls sometimes from clients who will share that their adult children looked at their legal papers and were really upset or didn't like. And so now my clients want to change the paperwork to make their whoever is upset no longer upset. And that is not a good reason to change your documents. These documents are for you. They are to protect you while you are alive and incapacitated. They are to allow people who you trust and who you want to be able to help take care of things for you while you are alive and incapacitated. And it's to carry out your final wishes, and pass on your legacy for after you pass away. So to alter the documents to do something that you don't necessarily want, but just to appease someone else, is not a good idea. It can be sometimes very stressful, borderline undue influence. And so I often encourage my clients to step away from the situation and take some time, um, because you don't want to alter your documents for it to be something that you ultimately don't want. That's not what these are for. Mistake number 15, failing to remove a decedent from title. It's always a good idea to update title records after somebody passes away, um, for many reasons, not the least of which is identity theft and fraud. But with respect to houses, sometimes a couple of times I've had a situation where a house was owned by a husband and wife. One passed away. The survivor never removed them from title. Then the second one passed away. Now you have two deceased homeowners on title. It's a probate, a potentially complicated one. I had a situation once where the first homeowner died decades ago, and their death certificate, something happened where they were unable to get it from the Department of Vital Statistics, whoever distributes them from the county health department, and it caused additional delays in the probate, and it was just a mess. So when somebody passes away, it's just a good idea to remove them from title. With real estate documents, it's easy to do. We file an affidavit with the county recorder, attach an original death certificate. With bank accounts and investments, you provide a death certificate to the financial advisor or to the financial institution, and they will update it that way. It's good to keep title current and reflecting current ownership. And then finally, mistake number 16 is procrastinating and doing nothing. I have met with so many families over the years who come in time and time again, and they really want to get everything in order, but they're putting off the decision making because their adult children are in conflict, or they can't decide who should be in charge of medical decisions and who should be in charge of financial decisions. And also, sometimes it's hard to face these important decisions because it can be scary. And I completely understand that. But everything that people worry about today while they are healthy, they're only going to get worse if you are no longer healthy, or if something happens to you and you have not put your intentions and your wishes in writing. It can cause confusion, it can cause stress, it can cause conflict. Um, these documents are not set in stone. As long as you are alive and competent, you can always update them and make necessary changes. It's better to have something in place now to reflect what your current wishes are, knowing that they can be updated in the future as things change. But putting it off is usually the cause of all of the unnecessary legal troubles that come along, because it's too late then to do something once the event occurs. So this is not about, death per se. This is about taking charge of making important decisions and protecting yourself and empowering your loved ones who you want to be able to help you in the future, giving them the tools that they'll need to do those things for you. So it's a positive thing and it's important to do. And that takes me to the end of my presentation. I think we have, Nambi, you're going to share questions, I think, right?
Yes. Let me see if we have any. Let me stop sharing. Let's see. So we do have a chat box at the bottom part of your screen, and you're able to raise your hand where you can verbally ask a question if that's easier for you. But feel free to ask any questions. That was an awesome presentation. I know definitely so many people that just from the myths and from the last part too, just not doing anything if they're with the advanced directives or with any partners, or just don't want to ruffle any kind of feathers within the family. And it's really needed conversations, I think, that needs to have within families, and just for seniors as well, of any age really, just to make sure that you have these documentations in place.
Yeah, no, absolutely. And I know, with the questions, it's a lot of information, it's a lot to process. And so if anybody has questions that they think of after the fact, they can always send me an email or give me a call if I can help. Or sometimes stuff is private and they don't feel comfortable asking. So
yeah, let me stop recording.